Indian Constitutions, salient features. Salient feature of Indian Constitution. The salient features of the Indian Constitution: a framework for a complex polity. The Constitution of India, adopted on November 26, 1949 and enacted on January 26, 1950, is a monumental legal and political document. It is the longest written constitution of any sovereign nation in the world, a detail that reflects its attempt to meticulously govern an immensely diverse and complex society. From a political science perspective, its features are not a random assortment but a carefully crafted framework designed to establish a sovereign, democratic, and just republic while managing the challenges of pluralism, poverty, and internal strife. Its salient features represent a unique synthesis of global constitutional principles adapted to the specific historical and social context of India. Foundational and structural features. Lengthiest written constitution. Description. The Indian Constitution is an exhaustive document, originally containing 395 articles, 22 parts, and 8 schedules. It has since expanded to over 470 articles and 12 schedules through amendments. Reasons for its length. Administrative detail. It incorporates not only fundamental principles but also detailed administrative provision, reducing the scope for ambiguity and judicial overreach. The Government of India Act 1935, a very detailed document itself, was a major source. Diversity management. It includes elaborate provision to accommodate the country's vast diversity. Special status for certain states, Article 370 originally. Provisions for scheduled castes and tribes and official language arrangements. Integrated judicial system. It provides for a single integrated system of courts to administer both central and state laws, unlike federations like the USA, which have dual court systems drawn from various sources. The Constitution is not an original document but a bag of borrowings. The framers wisely adopted and adapted successful features from other constitutions. From the British Constitution, parliamentary system, rule of law, legislative procedure, single citizenship, cabinet system, prerogative, writs, bicameralism. From the US Constitution, fundamental rights, judicial review, independence of the judiciary. Okay, we have taken both from UK and US. Fundamental right, judicial review, independence of the judiciary, impeachment of the president, removal of Supreme Court and High Court judges, post of vice president. From the Irish Constitution, directive principles of state policy, method of election of the president, nomination of members to the Rajya Sabha. Other sources: federation with a strong center, Canada; concurrent list, Australia; emergency provisions, Weimar Republic of Germany; amendment procedures, South Africa. A blend of rigidity and flexibility. Description: the Indian Constitution is neither as flexible as the British, which can be amended by a simple majority, nor as rigid as the American, which requires a special majority of states. 3 tiers of amendment. Article 368. Simple majority of parliament for provisions like the creation of new states, abolition of legislative council, etc. Special majority of parliament, that is a majority of total membership of each house and a majority of not less than 2/3 of the members of that house present and voting, for amending most constitutional provisions, including fundamental rights and directive principles. Special majority of parliament plus consent of half of the state legislatures for provisions affecting the federal structure, that is election of the president, distribution of legislative powers, representation of states in parliament, the philosophical and ideological core, sovereign, socialist, secular, democratic republic. This quartet, proclaimed in the preamble, defines the fundamental identity of the Indian state. Sovereign, India is free from any external control and has the power to legislate on any subject. Socialist, added by 42nd Amendment, implies a commitment to achieving social and economic equality through democratic means, not state ownership alone. Secular, added by 42nd Amendment, state has no official religion and treats all religion with equal respect. It implies positive secularism where the state can intervene to reform religions Democratic, the government is based on the will of the people expressed through periodic election based on universal adult suffrage. Republic, the head of state, the president is elected, not hereditary. Fundamental rights, part 3. These are justiciable rights that protect individual from the arbitrary authority of the state. They are essential for the development of an individual's personality. The 6 categories: right to equality, Article 14 to 18, right to freedom, Article 19 to 22, right against exploitation, Articles 23 to 24, right to freedom of religion, Article 25 to 28, cultural and educational rights, Articles 29 to 30, and right to constitutional remedies, Article 32. Article 32, called the heart and soul of the Constitution by B.R. Ambedkar, Dr. B.R. Ambedkar, it gives citizens the right to move the Supreme Court for the enforcement of fundamental rights. Directive Principles of State Policy, Part 4. These are non-justiciable guidelines for the central and state government to follow while framing laws and policies. They aim to establish a social and economic democracy. Examples: provision of adequate means of livelihood, equal pay for equal work, protection of children, promotion of educational and economic interests of SCs and STs, and other weaker sections. Significance: they present the positive obligations of the state balancing and the negative liberties of the fundamental rights. Fundamental duties, Part 4a, added by the 42nd Amendment in 1976. These are moral obligations of all citizens to promote a spirit of patriotism and uphold the unity of India. Significance: they remind citizens that while they enjoy rights, they also have the duties towards the nation and the society. The governance architecture, parliamentary system of government. India adopted the British Westminster model. Key feature: nominal and real executives. The president is the nominal head, while the prime minister and the council of ministers are real executive. Majority party rule. The party with a majority in the Lok Sabha forms the government. Collective responsibility. The council of ministers is collectively responsible to the Lok Sabha. Double membership. Ministers must be members of parliament. A federal system with a unitary bias. India is described as a quasi-federation or union of states. It has federal structure but with a strong unitary feature. Federal features: dual polity union states, written constitution, division of power, union list, state list, concurrent list, supremacy of the constitution, independent judiciary, bicameralism, unitary non-federal citizens, non-federal features, single constitution and citizenship. Strong center, union's list has more important subject, residuary powers with center. Appointment of governors by the center. Emergency provision, Article 352, 356, 360. All India services, integrated judiciary. Integrated and independent judiciary. The Constitution establishes a single integrated judicial system with the Supreme Court at the apex, high courts in the states and subordinate courts below them. Independence is ensured through a fixed tenure or difficult removal process, impeachment, salaries and expenses charged in the Consolidated Fund of India, ban on practice after retirement. Single citizenship. Unlike the USA, where the citizen is a citizen of both the US and particular state, India has a system of single citizenship. All citizens, irrespective of the state they reside in, enjoy the same set of rights. This is a powerful tool for promoting national unity and integrity. Unique and adaptive mechanisms. Emergency provision, part 18. These are the most controversial critical features designed to convert the federal structure into a unitary one during crisis. 3 types: national emergency, Article 352, due to war, external aggression and armed rebellion. State emergency, President's rule, Article 356, due to failure of constitutional machinery in a state. Financial emergency, Article 360, due to a threat to the financial stability or credit of India. 3-tier government. To 73rd and 74th Constitutional Amendment Act 1992 added a third tier of the government, the rural and urban local self-government, Panchayati Raj institution and municipalities. There is constitutionalized grassroots democracy and decentralized power. Special provisions for weaker sections and linguistic minorities. The Constitution reflects a deep commitment to social justice. It includes provision for the reservation of seats in legislature, government jobs, and educational institutions for scheduled castes, scheduled tribes, later for other backward castes, classes, OBCs. It also protects the cultural and educational rights of linguistic and religious minorities, Article 29 to 30. Judicial review, borrowed from the US, this is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state government. The doctrine of basic structure, propounded by the Keshav and Bharati case 1973, is a unique Indian contribution to this principle, stating that Parliament cannot amend the basic features of the Constitution. Conclusion. The salient features of the Indian Constitution reveal it to be a transformative document. It is not merely a legal framework for governance but an instrument for social change. Its genius lies in its ability to balance seemingly contradictory principles. It is rigid yet flexible, federal with a unitary spirit, liberal in its rights, provisions, and socialist in its directive principles. It is a living document that has successfully guided a nascent, diverse nation through immense challenges, proving its resilience and enduring relevance as the cornerstone of the Indian Republic. This topic is completed. We'll meet in the next topic of this paper in the next video. Okay.